Hello everyone, welcome back to today's topic of the day. Today, we'll be talking about obscenity, its laws and judgments in India. We'll be discussing about obscenity laws in India, related Supreme Court judgments, Hickland test and also the American Roth test. Now, the BJP Women's Wing president complained against actress Urfi Javed for roaming around on the streets of Mumbai in obscene clothes. However, NCP leader Supriya Sule urged the Maharashtra Deputy Chief Minister to stop targeting women in the state. Earlier also, there have been instances of obscenity charges. Obscenity laws in India predate independence. They have been used in colonial India against writers such as Saadat Hasan Manto and Isma Chughtai, whose works included traverse themes of sexuality. Model and actor Milind Soman has been booked for obscenity in 1995 and again in 2020. And recently, in 2022, Bollywood actor Ranveer Singh was booked for obscenity for posting pictures of his nude photo shoot on social media. Let's understand the obscenity laws in India. Under the Indian Penal Code, IPC, Sections 292, 293 and 294 deal with the offence of obscenity. Section 292 says that any content shall be deemed to be obscene if it is lascivious or appeals to the prurient interest, or if its effect tends to deprave or corrupt persons likely to read, see or hear the content. This section prohibits the sale or publication of any obscene pamphlet, book, paper, painting, and any other such materials. Section 293 deals with sale or distribution of obscene objects to any person under age 20 or an attempt to do so. Section 294 punishes obscene acts or words in a public place. To be considered a crime, the obscenity must cause annoyance to others. Further, with the advent of digital age, laws were made to criminalize obscene conduct on the internet also. Under Section 67 of the Information Technology Act 2000, anyone who publishes or transmits obscene material in electronic form can be punished. Now, what is considered obscene? The Oxford Dictionary defines obscene as offensive or disgusting by accepted standards of morality and decency. But for the lawyers, the meaning of obscene is not that easy to settle on. The courts, for their part, have developed tests to determine whether something is obscene. First, the Hickland test. In 1965, the landmark Ranjit Udeshi judgment of the Supreme Court adopted the Victorian-era Hickland test. First laid down in England in Regina versus Hickland, 1868, the test assessed obscenity by the standard of someone who was open to immoral influences and was likely to be corrupted or depraved by the material in question. When approached from this angle, a wide range of material could be obscene. Next is American Roth test. Over the years, the judiciary has narrowed the scope of obscenity. In the 𝐘𝐨𝐮𝐲𝐿 case of 2014, the Supreme Court did away with the British Hickland test and adopted the American Roth test instead. As per this test, obscenity was to be evaluated like an average person would, applying contemporary community standards. In its judgment, the court said, while judging as to whether a particular photograph, an article, or book is obscene, regard must be to the contemporary mores and national standards and not the standard of a group of susceptible or sensitive persons. It added that the photograph must be taken as a whole and seen with the context of what it wants to convey. Talking about the freedom of expression and obscenity, Article 19 of the Constitution of India guarantees the right to freedom of speech and expression and provides for reasonable restrictions on various grounds, including that of decency and morality. Indian courts have often settled the debate between morality and freedom in favor of artistic freedom, such as in the M.F. Hussain judgment of 2008 and the Perumal Murugan judgment of 2016. In the latter, the Supreme Court held that art is often provocative and is not meant for everyone. Material cannot be labeled as obscene simply because it is unpalatable to one section of the society. Now that was a little bit about obscenity. Let's take a practice question from the topic. Consider the following statements regarding obscenity laws in India. Statement 1. Section 292 of the Indian Penal Code prohibits the sale or publication of any obscene pamphlet, book, paper and painting. Statement 2. Section 294 of the Indian Penal Code punishes obscene acts or words in a public place. Now, which of the statements given above is or are correct? You may take a moment and give your answer in the comment section below. Now, the correct answer is C, that is, both the statement 1 and 2 are correct. I hope you liked the video and found the information useful. You may also check out our daily current affairs section on our website, and for more such videos, stay tuned to the next IAS YouTube channel.